Hello everyone, my name is Shivangi Tiwari and I'm from Hidayatullah National Law University. Today in this video, I'll be dealing with appearance and non-appearance of parties under Civil Procedure Code. So in this video, the topics that I'll be covering are appearance of parties. Secondly, we'll be dealing with the cases where neither of the party appears, and then where only the defendant party to the suit appears before the court of law, and what happens in the cases where summons are not duly served to the defendant party. Lastly, we'll be dealing with appeal, revision and review under Civil Procedure Code. So, appearance and non-appearance of the parties in a civil suit is a very important factor upon which the fate of any case depends. So, a mere non-appearance by a party in front of the court on the determined day may result in the adverse action with respect to the non-appearing party. The general provisions contained under Civil Procedure Code is based on the principle that no proceeding which is detrimental to the interest of any of the parties to the suit shall be conducted in the court of law. The provisions with respect to the consequences in cases of non-appearance of parties and other related provisions are contained under Order 9 of Civil Procedure Code. So here the appearance can be made by the parties in person or through his advocate or through any person along with the advocate of the party. In Civil Procedure Code, the mere presence of party before the court of law is not what the word appearance under Order 9 means. But here the word appearance means the appearance made by the pleader who is able to answer all the relevant questions in the judicial proceedings. Rule 1 of Order 9 declares mandatory presence of the parties before the court of law on the date which is determined by the court. Rule 2 of Order 9 declares that failure on the part of the plaintiff to submit any process fee which was determined by the court of law on the stipulated day would result in the dismissal of suit by the court. Now, what happens when neither of the party appears in the court of law? So, Rule 3 and Rule 4 of Order 9 of the CPC deals with the cases where neither of the parties in a case appears before the court on the date fixed by the court of law. So, according to Rule 3, in such cases, the suit shall be dismissed by the court, and according to Rule 4, the plaintiff can file a new suit in the court of law if he is able to satisfy to the court that there was some sufficient reason due to which he was not able to appear in the court on the due date. And in certain cases, only the defendant party to the suit appears. So the provisions with regard to these cases are contained under Rule 8 of Order 9 of Civil Procedure Code, which talks about the legal consequences of non-appearance of the plaintiff and appearance of the defendant in court of law. In such cases, the court can make an order of dismissal of the suit unless the defendant admits a claim or parts thereof. As in such a case, the court can pass a decree against the defendant upon such admission or where only the part of the claim is admitted. So now what happens where the summons are not duly served to the defendants? So Rule 6 of the Order 9 contains the provisions where only the plaintiff appears before the court but the defendant remains absent from the court on the date which was fixed by the court. So in all such cases, the court has the authority to decide the consequences of such non-appearance with respect to the status of the summons which is served to the parties in the case by the court of law. So there are certain course of actions which the court may resort to based on the status of the summons which was served. So in cases where the summons are duly served then the court can declare that the suit shall be heard ex parte. Secondly, in cases where the summon is not duly served, then the court can order the issue of a second summon, and that the same is to be served to the defendant. Now, thirdly, where the summon is served to the defendant, but sufficient time was not given to him to make an appearance in the court of law and answer the material questions. In such cases, the court has the liberty to postpone and fix the hearing of the case on some other day, which shall be notified to the defendant. And lastly, when in a case the delay of issuance of issuance of summon to the defendant is due to the fault of the plaintiff, the court may order the plaintiff to pay the costs which occasioned by the delay in the proceedings. Lastly, a last topic in this video is appeal, revision and review under CPC. So the provisions related to appeal are contained under section 96 to section 112 of part 7 of the Code of Civil Procedure. Appeal means the removal of a cause from subordinate court to a superior court in order to test the soundness of the decisions which was passed by the subordinate court. It is the continuation of original proceedings before the superior courts, and the superior court need not always be a higher court, as it can even be a subordinate court like a district court. And then revision is dealt with under section 115 of CPC, which confers revisional jurisdiction to the high courts in the country. Under the revisional jurisdiction, the high courts can entertain any revisional petition filed by any party which is aggrieved by any judgment, order, decree passed by any subordinate court in the country. The limitation period for filing any revisional petition against any order, decree or judgment is that of 90 days from the passage of such order, decree or judgment. Lastly, we'll be dealing with review. So the provisions with respect to review are contained under section 115 of the Civil Procedure Code. The grounds for review of the judgments are, firstly, when the applicant discovers a new evidence which is material to the determination of the judgment of the case, which due to the negligence or on his part or due to any other reason was not able to be presented before as evidence before the court of law. Secondly, the orders of review is passed only in those cases where the error is in the face of records and not with respect to the facts of cases. What constitutes the face of records has to be determined by the courts on the case-to-case basis, keeping in view the facts and circumstances of the case. Thirdly, any misconception on the part of any court may be regarded as a sufficient cause to review the judgment. That's all for today's video. I hope you find this video helpful. Thank you.